Good idea.
Judges of the New York State Court of Appeals. The ceremony will now begin. All please be seated.
Colleagues and honored guests, good afternoon. Each year as I prepare to report on the state of the judiciary, I search for a theme around which to organize the plans and achievements of one of the largest and busiest court systems in the nation, if not the entire universe. And quite frankly, despite the search for something new and different every year, in the end, my theme turns out to be a thinly disguised version of meeting today's challenges, which is, and I imagine will forever be, a coalescing principle for everything we do. The unending challenge for us is to assure access, efficiency, stability, and the delivery of justice, while at the same time accommodating breathtaking societal change so that the courts remain relevant and responsive to modern-day life. This year, however, the arrival at the Court of Appeals of our long-awaited draperies focused my attention, and they are beautiful, aren't they? Focused my attention on a different sort of change, the physical, tangible change that has transformed Court of Appeals Hall from a dignified 19th century facility last updated 45 years ago to a dignified 21st century facility enlarged and equipped to meet today's issues. As my colleagues and I had postponed any thought of a formal ceremony, awaiting the arrival of these finishing touches, it occurred to me that we might view today as a dedication or a rededication. In a sense, dedication is another perpetual coalescing theme for the New York State court system. And in fact, there's even a certain logic in declaring this a dedication of our refurbished facility. I note that on January 14, 1884, when the Court of Appeals first occupied this very courtroom, then situated across the street at the Capitol, no formal ceremonies took place, though on that day, as the press reported, a large number of prominent persons were present for the occasion. And some decades later, on January 8, 1917, after the courtroom was moved piece by piece from the Capitol to this stately edifice, then renamed Court of Appeals Hall, Governor Charles Whitman noted that judging from the splendid character of the building itself, we trust for centuries it is to be devoted to the noblest purpose for which a building or a life can be devoted, the administration of justice. Today, 121 years after the Court of Appeals first occupied this magnificent courtroom, the judges once again are present with a large number of prominent persons, all of you. And so we once again affirm our dedication to the noblest purpose to which a building or a life can be dedicated, the administration of justice. I know that in this regard I speak for every one of my Court of Appeals colleagues, for the presiding justices who surround me and the chief administrative judge, and all of the judges and the non-judicial personnel who make up the unified court system. Though I doubt that the celebrants in 1884 or 1917 or even 1959 could possibly have foreseen the size or complexity of today's dockets, we stand shoulder to shoulder with them in recognizing our great trust, our great privilege as the third branch of government to administer justice under law. On this occasion, we deeply thank our partners in the executive and legislative branches, several of them here today, for enabling us to maintain our beautiful home and for the many cooperative efforts that help us all better serve the public. In reporting on the court system's achievements and plans, I begin as I did last year with families, where the challenge of societal change and the long-term impact we have on people's lives are perhaps the greatest. Family issues, divorce, foster care, domestic violence, child support, child abuse and neglect, juvenile delinquency continue to account for about 1/5 of our dockets, an astounding 800,000 new filings in the year 2004. Within the broad subject of family justice, I turn first to the subject of matrimonials. For all the monumental change around us, one thing remains constant, and that is complaints about matrimonials. Too much delay, too much money, too much grief, too much pain. Indeed, 14 years ago, my predecessor, Chief Judge Saul Wachtler, responded by constituting a committee to examine lawyer conduct in matrimonial actions, chaired by then First Department Appellate Division Justice E. Leo Malonis. My own membership on that committee ended when I became Chief Judge, but I will never forget the testimony, the submissions, the literature, the emotion that surrounded the subject of matrimonials. A dozen years later, I announced the formation of a second commission chaired by Second Department Appellate Division Justice Sandra Miller, who is among us today, to take an overall look at the divorce process in New York and recommend reforms to correct existing problems. As the press clippings alone reflect, there is no shortage of public interest or public ire on the subject of matrimonials. Not that we haven't made real progress throughout the past decade. Perhaps most significant has been the appointment of a statewide administrative judge for matrimonial matters, and I see Justice Jacqueline Silberman here. And here again I invoke my theme word of the day, dedication, because it so aptly describes the spirit and the skill that Justice Silberman has brought to her role, and the matrimonial judges under her aegis have brought to theirs. I count as progress the many rule changes since the Malonis Committee's report, among them a requirement of written retainer agreements, a prohibition on non-refundable retainers and certain security interest fee arbitration, hands-on case management by dedicated judges, meaning this time judges assigned exclusively to matrimonials, and provision for interim awards of legal fees to help put the litigants on equal footing in court. Then, too, in the highly charged area of child custody, another dedicated group, the Parent Education Advisory Board, chaired by Monroe County Supreme Court Justice Evelyn Frazee, has worked diligently to develop standards for parental education programs so that battling litigants understand the impact of divorce on their children. And at the same time, we've been developing a model custody part, which will be operational in New York County by year-end, that will apply best practices for custody disputes, including such tools as mediation, stress management, counseling, and links to appropriate services such as parent education programs. But despite all of this effort, the overwhelming judgment regarding matrimonials today continues to be too much delay, too much money, too much pain, too much grief. During these years, another constant refrain has been that our statutory law requiring proof of fault under one of four specified grounds, or requiring a full year's wait after an agreed-to written separation agreement ending the marriage, should be re-examined. The refrain has grown louder and louder as consensus has built, most recently including the New York State Bar Association and the New York Women's Bar Association, for some form of no-fault divorce, and New York has increasingly become isolated and unique among the states in its statutory requirements. After long and careful reflection, I too have come to see that requiring strict fault grounds may well simply intensify the bitterness between the parties, wasting resources, hurting children, driving residents to other states for a divorce, and delaying the inevitable dissolution of the marriage. And I too join in urging legislative review. I deeply appreciate that this issue raises very hard questions on all sides, but I am hopeful that with interest in statutory change from so many diverse groups, a fair proposal can be reached, one that will scrupulously safeguard the interests of the most vulnerable litigants, especially the already disadvantaged poor and victims of domestic violence, while providing needed relief from the fault requirement. It goes without saying, but I'll say it anyway, that as the merits of statutory reform are studied by the legislature, we in the judicial branch will continue to keep a spotlight trained on ourselves, both through Justice Silberman's day-to-day oversight of matrimonial litigation and through the Miller Commission's more global analysis of the present system. Of course, where delays occur in any category of family court proceedings, it's the children who are the losers. Our efforts, therefore, have been dedicated both to promoting effective procedures for case resolution and to collaborating with other groups and agencies in order to deliver justice that is meaningful. Too many children are growing up in family court. Too many children are graduating from family court to criminal court. They certainly deserve better. We are now in our third year of Adoption Now, which is my own personal collaboration with Commissioner John Johnson of the New York State Office of Children and Family Services and Commissioner John Mattingly of the New York City Administration for Children's Services. And the results, I'm pleased to tell you, have been just terrific. Adoption Now focuses on avoiding delays in the achievement of permanent homes for children whose birth parents' rights have been terminated. In November 2004, we not only had another record-setting Adoption Day program, but also the United States Department of Health and Human Services recognized these collective efforts with a federal Adoption Excellence Award. Additionally, reflecting achievements in finalizing a record number of adoptions and particularly in meeting the challenge of finding permanent homes for children over 9, New York State received approximately $3.4 million through the Federal Adoption Incentive Program. The rewards of working together have been even greater for each of us in streamlining our adoption procedures, but they have been greatest of all for the thousands of foster children who are now in permanent homes. Adoption Now has spawned a variety of other collaborative efforts. Together with our Permanent Judicial Commission on Justice for Children, the Adoption Now work group has taken its program statewide, presenting a dozen sharing success seminars for judges, court and agency staff, and others involved in adoptions and foster care. These seminars demonstrate the success of convening case conferences early on at which services are put in place to repair fractured families, thus enabling children to remain in their homes. Where returning a child to home is not possible, intensive case management facilitates timely movement toward adoption or kinship placement or other permanent outcome. And in Erie, Otsego, and Kings County family courts, we're making creative use of mediation to narrow and eliminate disputed issues and expedite permanency for children. Recognizing that family courts must be vigilant in ensuring that the needs of the children before them are met during what may be years and years of foster care, the Permanent Judicial Commission on Justice for Children has issued a Healthy Development Checklist, a tool to improve decision-making that has become a national model, and again, reflecting our successful collaboration that benefits all children in foster care. I'm proud that our checklist has been hardwired by OCFS into, I know this is a good thing, into its connections computer system that's used statewide to track these cases. Our Babies Can't Wait initiative also builds on this focus by targeting attention on this most vulnerable group, infants under the age of 1, surprising for me, the largest segment of New York's foster care population and the most likely children to enter and re-enter foster care. Like Sharing Success, our Babies Can't Wait project has been on the road statewide, providing multidisciplinary training to everybody who's part of the foster care process. With support from the New York Community Trust, an early childhood specialist is now in the New York City Family Court, and our wonderful court-appointed special advocates, volunteers, have been deployed to ask the Healthy Development Checklist questions. The preliminary results of these efforts are heartening in terms of avoiding what could otherwise become lifetime disabilities for these infants in foster care. But maybe best of all, ACS and the Babies Can't Wait work group are working together to make an infant's very first placement in foster care the last and only one, and what a great achievement that would be. We continue our efforts to enhance access to the courts and ease the process, especially for the thousands of self-represented litigants who are in family court. One such effort is our e-petition pilot project in Brooklyn and Bronx Family Court, which enables litigants to prepare and file simple petitions right at computer terminals in the courthouse. And in collaboration with, and collaboration is a big word for us, in collaboration with the State Office of Temporary and Disability Assistance, The pilot project will soon be expanded so that a custodial parent can be interviewed at and a petition prepared by the Child Support Agency, which can then immediately transmit the petition electronically to family court. The initiatives I've described, and there are so many more, exemplify what can be accomplished through dedication, through collaboration, and perhaps above all, through sheer perseverance. The bottom line, however, is that our most basic, our most important family court resource is severely limited, and that is the number of judges in the family court who handle these cases every day. The simple truth is we need more family court judges. Even the staggering volume of family court filings does not begin to convey the pressures and demands that accompany this particular increased workload. Judges not only have more cases, they also have more deadlines to meet as a result of ASFA, the Adoption and Safe Families Act, and other federal mandates. Just 2 years ago, in a joint effort with New York City Mayor Michael Bloomberg, 8 judges were added to the New York City Family Court through a stopgap measure by filling interim civil court vacancies with judges qualified for family court and by assigning qualified judges sitting elsewhere. This response provided some welcome relief in New York City, but the truth is the problem is statewide, as Judge Plumidor knows so well. Indeed, last year's increase in family court filings was actually greater outside New York City than within New York City. We need a coherent and permanent solution, one that recognizes the crucial role of family courts in today's society. I therefore call upon the legislature to create additional family court judgeships statewide to enable us to meet the urgent demands of family court litigants. We will shortly provide the legislature with detailed documentation county by county, amply supporting our request. In family court, as throughout the court system, we understand the importance of deciding each case fairly and efficiently, of improving case management methods, of enhancing access to justice for all litigants, and of using new technology to simplify everything we do. But we also see that certain types of cases require us to look beyond traditional case processing if we are to achieve interventions that are meaningful. And that is why we are collaborating with others outside the court system in the area of adoption and foster care. That is why we have created multidisciplinary groups to identify and implement change for the benefit of children and families in the courts. That is why we have developed problem-solving courts, such as community courts and mental health courts, to address the multifaceted societal problems that people are increasingly bringing into our courts. And that is why we have embarked on operational restructuring to ease the burdens, especially for families plagued by domestic violence, which is my next topic. Through bitter experience, we have all learned so much about the scourge of domestic violence. We have learned, for example, that often domestic violence victims have ongoing intimate relationships with the batterer, living together, raising children together, the victim entirely dependent on the batterer, even for life's essentials. Since the recidivism rate for violent crimes between intimates is 2.5 times that for crimes between strangers, we know that these individuals are very likely to be back before us again and again and again with escalating violence, even fatalities. So simply resolving the legal issue that is before us is not necessarily resolving the matter. We've learned that for justice to be effective, courts from the outset must be mindful of victim safety. They must be mindful of the potential for future abuse, and they must be mindful of the need for links to agencies that can deal knowledgeably with domestic violence. To this end, we embarked on a pilot project in Kings County, a collaboration with the district attorney, with Safe Horizon, with the Center for Court Innovation, and others. That first court, like many we have opened since, includes an assigned, dedicated judge and court staff, enhanced monitoring of defendants, and a coordinator to link the parties with outside services that are so necessary. 4 years ago, we turned our attention to the added burden placed on victims of domestic violence by the very structure of the New York State court system, which requires litigation in several separate trial courts: family court for child custody or visitation, criminal court for an assault, Supreme Court for a divorce. Placing the problems of one family before one judge who can deal comprehensively with the issues is plainly better for the families, and it's better for the courts. That insight led to the creation of the Integrated Domestic Violence Court. We began a pilot in each of the 4 judicial departments and then announced our statewide expansion in 2002. Today, with the leadership of Deputy Chief Administrative Judge Judy Kluger, we have 18 integrated domestic violence courts throughout the state. I think that's something that deserves applause, too. 18 of these courts, from our most rural to our most urban communities, and we're on target to meet our goal of serving the tens of thousands of domestic violence litigants throughout the state by year end. The IDV experiment has become integral to court system operations, demonstrating both that diverse stakeholders can work together to improve process and outcome, and that eliminating artificial barriers among our trial courts benefits the public as well as the courts. And so long as I am on the subject of integration, and to end any suspense any of you might have, yes, we will continue to pursue, as a constitutional reform, the streamlining of our trial court structure. Now, talk about dedication. Although we are doing everything we can administratively to eliminate needless jurisdictional hurdles that make the court system cumbersome and inefficient, in the end it's clear that the state constitution should be amended to consolidate our many trial courts into a single unified Supreme Court. My next subject is a related one, the Bronx Criminal Division, another operational measure that rests on the lessons of experience and really good sense. Last year's plan to join the operations of Bronx County Criminal Court and the criminal term of Supreme Court into a single trial court became a reality exactly 3 months ago on November 8 under the leadership of Judge Kluger. The Bronx County Criminal Division is a single streamlined court of criminal jurisdiction, allowing us to use resources as caseloads dictate without the barriers inherent in a 2-tiered system. Already, the division is making significant inroads on our backlogs, reducing felony and misdemeanor inventories, and we fully expect that this decline will continue. As part of the initiative, we will now be introducing Bronx Community Solutions, which brings the community court problem-solving model to nonviolent criminal cases entering the consolidated court, and that includes extensive screening and assessment of offenders, linkage to an array of on-site and community-based social services, and vigorous monitoring of compliance with services mandates. Through both punishment and help, the court can hold offenders strictly accountable and yet, where appropriate, offer them access to assistance in order to prevent future repeated criminal conduct. One of the earliest applications of the problem-solving model was our drug court program. Drug courts link eligible offenders with drug and alcohol treatment as an alternative to incarceration or removal of their children to foster care. Under the State Office of Court Drug Treatment Programs, we've been moving drug courts into the mainstream of court operations as an integral part of our criminal and family justice programs. Having first piloted a drug court in Rochester in 1995, and we're about to celebrate our 10th anniversary, by the end of 2004, we had 125 drug courts operational all across the state with 6,000 active participants. These courts have given a fresh start not only to the thousands of addicts charged with nonviolent crime, but also to 380 drug-free babies born to female drug court participants. Can you think of a better alternative for handling these cases? We can't. I would review the statistics on reduced recidivism and cost savings to the state, but I'd rather just tell you a story I heard recently from Washington County, where the judge overseeing drug court tragically took his own life. Drug court participants wanted to do something to memorialize the judge. They chose a project, a memorial bench. They made drawings, solicited donations of material, set up an account at a local bank, and secured county approval for the project. As the chief clerk of the court wrote, "Now we have people who know how to network, who can put a project together from beginning to end, who are meeting with public officials on their own, who are working toward a common goal. Some of these people couldn't get from point A to point B before entering the drug court program. This project alone gives me fuel to continue touting the importance of this court." Family and criminal court cases are not the only ones in which resolving a legal issue may not resolve the matter. Housing court presents another example. For thousands upon thousands of housing court litigants, the issue that brings them into court, typically non-payment of rent, is only one of a spectrum of problems they face: unemployment, drug and alcohol abuse, truant and disabled children, depression, and disease. Additionally, because of the unremitting shortage of lawyers to represent them, they must proceed in court on their own without a lawyer. Two initiatives being implemented in the New York City Housing Court are aimed at keeping these people in their homes instead of living on the street or in prison, and changing the direction of their lives. As to both initiatives, I am grateful to New York City Civil Court Administrative Judge Fern Fisher for the ideas and for her perseverance in carrying them to fruition. The first initiative, the Housing Help Program, focuses on families in zip code 10451, largely low-income tenants, residing in an area of the Bronx afflicted with high rates of homelessness. When these families appear in court, they will be referred immediately to a help center located right in the Bronx Housing Court, where they will be screened by a lawyer and a social worker together. And they will be offered a full range of services, including, for example, access to job training, to treatment for diabetes, and they will be offered access to subsidies and entitlements that will enable them to pay their rent. Again, as with all of these initiatives, the court system does not itself supply the services. We simply make them more accessible by offering a little bit of space under our roof to the people who do. In this case, it is United Way of New York City that is funding the services and legal services for New York City and women in need who are actually providing the services. The objective here, again, is to prevent homelessness, to secure the payment of rent where that is due, and to keep these families in their homes where that is possible, instead of triggering the inevitable downward life spiral that follows evictions. Thank you, United Way of New York City, and its president, Larry Mandel, is here today. Thank you. Where are you, Mr. Mandel? Thank you so much for making this wonderful initiative possible for us. Our self-represented project is a second housing court collaboration, this time with Columbia Law School and its Lawyering in the Digital Age Clinic. And I especially thank the two fabulous second-year law students who have been critical to this initiative. Where are you? Allison Monahan and Arinzi Ike. Columbia Law School has helped us develop a web-based automated system, a decision tree, to guide the thousands of self-represented tenants in rent-stabilized apartments owned or managed by the New York City Housing Authority as they answer non-payment petitions. We celebrate the initiative that will provide vital answers for these unrepresented litigants facing eviction. We celebrate the promise this initiative holds for the many litigants throughout our court system who must proceed without a lawyer, and we celebrate a great collaboration with the Columbia Law School, which we hope can be continued, enlarged, replicated with every single one of New York State's law schools. Of course, not every civil case raises the same kind of challenge as the family and housing cases that present an array of social problems as well as legal issues. We also face the challenge of effective management of civil dockets of every variety, from a fall on an icy sidewalk to a failed worldwide business transaction. In all, these civil cases account for more than 1.5 million new filings a year and very heavy caseloads for every one of our judges. That alone puts special emphasis on the need for careful case management and docket control. Justice is enhanced when judges supervise the progress of every case, when they set meaningful deadlines, when they provide credible trial dates, and when they adhere to them. Last year, I promised a fresh look at what we have accomplished and what we have yet to accomplish since introducing a comprehensive civil justice program, bringing differentiated case management methods to our highest volume counties throughout the state. Today, we release our full report. We celebrate it too. It's available to you, and I'm pleased to tell you that the results are nothing short of dramatic. While civil case filings in Supreme Court have increased steadily, the period between filing and disposition has actually decreased more than 35%. Wonderful news, Attorney General Spitzer, isn't it? Our courts both resolve more cases and resolve them more efficiently. In short, under this new program, we're managing our caseloads better, and we're providing justice to more New Yorkers than ever before. So what's next? Under the new program, we'll begin to use only one case measurement, the time between filing a request for judicial intervention and case disposition, which will allow the judges much more flexibility to adjust the discovery periods to meet the needs of every single case. We'll also be introducing greater automation, allowing attorneys to email, not something we do a lot, discovery schedules and other information rather than having to appear in person. And we will enlarge specialization, which has been a proven success with commercial and matrimonial litigation. We will be expanding specialization into the areas of guardianship and medical malpractice litigation. We believe that these steps, along with the others to come, all of them outlined in the report available to you today, will increase and continue our significant process in effective management of civil cases. For many commercial practitioners and their business clients, overburdened dockets once made our state courts an unattractive forum for their litigation. By the late 90s, however, we witnessed a sea change as these parties actually began turning to the New York State courts as their forum of choice. And why the change? 3 words: the commercial division. As with other initiatives, we started small with 4 Supreme Court justices in Manhattan, designated to hear only commercial cases exclusively and to preside over each case from beginning to end. The response was phenomenal, and thus the commercial division was born, with 5 parts in Manhattan and 1 in Rochester. Today, the commercial division operates in business centers all across the Empire State, and I'm happy to report that the list, which now includes New York, Monroe, Erie, Albany, Westchester, Nassau, Suffolk, and Kings counties, will grow in 2005 to include Queens County. Innovations and fine-tuning of commercial division practice has, of course, continued throughout the decade. With the growth of the division, however, lack of statewide uniformity increasingly became a concern. I'm pleased to add that as part of today's comprehensive civil justice program report, we are releasing for public comment a set of proposed uniform rules for the commercial division, including definitive guidelines on a most basic question: what is a commercial case? And with that, I'm going to turn to filing by electronic means, which we have come to speak of simply as FBEM. The project was first authorized by the legislature in 1999. FBEM allows litigants to commence certain types of lawsuits electronically and then to continue to exchange papers online. Since its inception, we've provided a great deal of training to the bar, to the court staff, and we've worked to simplify the system. Last year, these filings doubled, and we're hopeful that this trend will continue. As the experiment has expanded to new localities and courts, we've established a resource center to assist in the smooth introduction of FBEM to the bench and the bar. With the most recent extension of the authorizing statute sunsetting in September, we will be working with the legislature to extend and hopefully to further expand this very important project. Along with ongoing efforts to improve the delivery of family, criminal, and civil justice, we will continue to work to assure that the courts are fully accessible to the public we serve. I will mention just a few of our many initiatives in this area, some involving the availability of counsel, others involving the availability of information. Access to justice for criminal defendants means the right to adequate, effective legal counsel regardless of ability to pay. Last year, we formed the Commission on the Future of Indigent Defense Services, chaired by Judge Burton Roberts and Professor William Hellerstein, to take a top-to-bottom look at New York's existing indigent defense system and tell us how we can make it better. On behalf of the Commission, the Spangenberg Group, a nationally recognized research and consulting firm, will be conducting a statewide evaluation of existing programs, and they will begin their public hearings this month, indeed on Friday in New York City. Making concrete proposals to enlarge the pool of attorneys available for indigent defense work, we know, is no small task, yet we are fully confident that the work of this commission will yield enormous benefit. On the civil side, on the civil legal services side, I've already spoken of litigants forced to proceed without lawyers in family court and housing court. Civil legal needs can also involve vital issues in other courts: divorce, orders of protection, public benefits, access to health care, and we know that the unmet civil needs are vast. This year, we will be moving ahead to implement fully the recommendations of our report, The Future of Pro Bono in New York, by establishing a more structured, and I emphasize the word voluntary, pro bono program. I underscore, we have absolutely no intention of mandating pro bono. We believe, however, that a partnership among the judiciary, the bar, service providers, and advocates for the poor, starting at the local level, will encourage lawyers to do much more pro bono work and help clients access available services. I have on many occasions publicly applauded lawyers for pro bono work, and I am happy to take that opportunity to do it again today. It's important for every one of us to recognize the extraordinary dedication of the many members of the bar who do pro bono work. Our access to justice initiatives include as well making information about the courts much more available to the public. Last year, our easy-to-use website, Court Help, was visited several 100,000 times. In this connection, too, we've been conducting public outreach efforts. Our clergy days have been, for me, surprisingly and wonderfully popular. It's just one example of an effort to try to get information about the courts into the hands of people who then can share it with their communities. And indeed, 8th District Administrative Judge Sharon Townsend is not among us today because today is the Buffalo Court System's Clergy Day. I'd like to report briefly on another initiative, which is to implement the wonderful report of our Commission on Public Access to Court Records, which was chaired by Floyd Abrams and had just absolutely wonderful members, including my colleague, Judge Graffio. We have started by increasing electronic access to court calendars and docket information and introducing online access to criminal calendars. The Commission recognized the need to protect individual privacy and security and proposed that litigants and their counsel be required to exclude from their paper or electronic court filings certain sensitive information like Social Security numbers, financial account numbers, names of minor children, and dates of birth. In keeping with the Commission's recommendations, we're going to begin a pilot project in Broome County this year as a collaboration between the courts and the Broome County clerk, and we will share responsibility for creating electronic copies of all future documents in case files. Now, you know that no report on the New York State courts would be complete without a segment on jury service. I count high on our list of achievements this past year the happy experience of presiding Justice Anthony Cardona, who deliberated to verdict as a juror in an Albany criminal trial, itself an example of the reality of universal jury service. Like other New Yorkers who serve to verdict, the presiding justice gives his jury service 2 thumbs up. Our goal is that more people called for jury service have the opportunity to deliberate to verdict on a case instead of just cooling their heels in jury waiting rooms. Having myself, during the year 2004, once again been struck from a panel, my 3rd unsuccessful effort at jury service, any further comment by me on the presiding justice's experience would surely be put down as sour grapes. For any number of reasons, jury system is and will remain a priority. Apart from the centrality of juries to our system of justice, more than 650,000 members of the public actually come into our courts to serve as jurors every year, many having their very first experience with the New York courts. That's at least 650,000 opportunities every year to show the public a justice system that works well and values their contribution. I think we've moved a lot closer to the mark, but the fact is there's still a way to go. One promising area of reform we have been pursuing is called the Jury Trial Project. 50 of our judges, 50 of them, across the state, stepped forward to try a few of the innovative practices. And they've just completed their first phase, the research phase, in which they have closely documented more than 100 civil and criminal trials. The report will be forthcoming very shortly, but I'd like to preview just a couple of their findings and insights. For me, what is perhaps most interesting was a survey among participating judges, lawyers, and jurors on each case as to whether they thought the case was complicated. The widely varying responses among these groups, I think, are very significant. Judges and lawyers, the court insiders, may think that a case is not complicated, but it turns out that the jurors think otherwise. Now, doesn't this tell us something important about the need to improve comprehensibility of court proceedings? Second, the survey of actual trials showed that the use of innovations improves jurors' ability to do their work without in any way undermining the system. And third, attorneys, often skeptical of change, once having experienced these innovations, say they are much more receptive to them. All in all, cause for optimism as we move ahead with jury reform. Along with a statewide program building on the jury project, we will this year continue to implement the recommendations of the Jury Commission chaired by Mark Souderer. Under the leadership of First Deputy Chief Administrative Judge Ann Pfau, we will begin a pilot project with Queens County as the model jury site, using new software to enhance communication, increased participation of judges and judicial hearing officers in the selection process, and we will continue to update and upgrade jury facilities. The fact is, jurors today expect so much more of the court system in summoning and in service. They expect, and rightly so, that their time will be well utilized and that they will be treated with courtesy and with dignity. We will continue our efforts to meet these expectations in full. And I now turn to the courts and the legal profession, beginning with fiduciary and guardianship matters. Last year at this time, we released a report showing the success of reforms implemented in 2003 to address abuses in fiduciary appointments. These reforms, recommended by the Commission on Fiduciary Appointments, involved the adoption of a new Part 36 of the Rules of the Chief Judge, the first step to ensuring that those appointed as fiduciaries are properly qualified and properly trained. The Fiduciary Committee, so ably chaired by Sheila Birnbaum, reconvened to review the impact of the new rules and examine remaining problems, and they've just issued their second report addressed to the oversight of guardians and of counsel to the public administrator. A guardianship proceeding, and we have thousands of them in our court system every year, can provide an ideal mechanism for protecting the rights of the elderly and disabled. The Commission found that the vast majority of guardians are skilled and dedicated advocates for their wards, responsibly managing finances and making health care and other critical decisions. But given the sweeping control guardians exercise over their wards, proper court supervision is critical to ensure that personal and financial interests are fully protected. A key role is played by the court examiners, individuals appointed by the courts to evaluate guardians' reports. The Commission has now made excellent recommendations to improve the performance of court examiners, and we will work collaboratively with the presiding justices and the administrative judges to implement these recommendations. As to counsel for the public administrator, every county in New York State has a public administrator appointed by the surrogate who acts as the fiduciary of an estate where no eligible person is available to serve as the administrator or executor. Public administrators are represented by counsel, a private attorney who is paid out of estate assets for performing necessary legal services and preparing court papers. The Commission's report finds a systemic failure of accountability of the Public Administrators Council and recommends several measures that, again, we will work toward implementing in full. And at their best, well-trained, dedicated guardians can be vigorous advocates for the incapacitated persons for whom they are responsible. In an ideal system, not only skilled guardians, but also resources are available to ensure effective decision-making and the protection of incapacitated persons' interests. This year, we will establish a model guardianship part to address the unique needs of incapacitated persons. Located in Suffolk County, it will incorporate specialized training for family members appointed as guardians, introduce a mediation alternative into the Article 81 proceeding, and establish lines of communication with social services agencies and the district attorney's office so that allegations of financial or physical abuse receive immediate attention. In Kings County, we will launch another promising pilot program, appointing the highly respected Vera Institute as guardian in 50 random cases in the first year. With social workers, accountants, and attorneys on staff, the Vera Institute can provide a full range of services to an incapacitated person. In addition, beginning this month in a program we call Cooperative Assistance Network, Vera will serve as an additional resource for family and lay guardians in Kings County to help them fulfill their statutory obligations. And I turn next to the judiciary. I begin this section of my report on the judiciary with a subject that is of utmost importance for all of us, and that is the subject of judicial salaries. Last month marked the sixth year since judicial salaries were increased. The salaries of New York State judges were last adjusted in 1999. At that time, brought to full parity with federal district court salaries. 6 years later, we have fallen far behind federal judicial salaries, and we have fallen far, far behind the salaries of brand new lawyers at many large law firms. Judges certainly deserve fair compensation for what they do. Equally important, judicial salaries reflect the value that society places on our work, a recognition that as courts, the judges serve as the vehicle for delivery of justice in our system of government. We must ensure that the very finest individuals continue to be drawn to judicial service and that our outstanding bench is justly compensated on an ongoing basis. That is difficult to achieve when a judge's salary is eroded by an increase in the cost of living by 20% or more between sporadic salary adjustments. We need to address this issue directly this year, and we will, by submitting a legislative proposal for a long overdue increase. Without question, we are most grateful for the support that we have in the past received from the executive and legislative branches, and we are certainly mindful of the fiscal constraints under which New York State operates. The budget we have submitted this year, as in past years, reflects that reality. At the same time, there just has to be a better, more rational way of addressing the vital issue of judicial salaries. The federal government and many other states have identified effective mechanisms such as cost of living increases and commission-recommended adjustments to provide for regular salary reviews for public lawyers. New York and its judiciary deserve no less. New Yorkers have come to recognize and expect that the state courts are increasingly effective in meeting the needs of the citizenry. Our successes in meeting these expectations depend on our judges. They are the ones who make the court system what it is today. They should, in all fairness, be properly compensated. In another measure, to provide more information to the public, today we inaugurate a judicial directory on the court system's website, recognizing that a key feature of accountability is openness, not only about what we do, but also about who we are professionally. Striking a balance between providing information and protecting privacy and security, this directory will set forth the judge's educational background, their prior experience, and whether they reach the bench by election or by appointment. As of this very afternoon, the directory is available to every single one of you at the click of a mouse on the court system's website. As is evident even in this capsule report, a boundless range of issues faces today's courts, from mind-boggling substantive law questions to novel problem-solving approaches to effective case management. Plainly, it is imperative that we remain fully up to date, current in the law, in new approaches and techniques for overseeing caseloads. The dream of our very own first-rate school, where everybody in the court system can sharpen their skills, became a reality 18 months ago with the opening of the Judicial Institute on the grounds of Pace Law School in White Plains. Every day, the dream just gets better and better, and I am so grateful to you, Dean Robert Keating, for that. Remarkably, just in a recent week, we had a 5-day orientation program for 77 new judges of the court system. We had substantive programs on guardianship, fiduciary matters, problem-solving courts, the latest on hearsay and search warrants, thank you, Judge Rosenblatt, complex business transactions and jury management, and our court attorneys, family court referees, court clerks, and law librarians also enjoyed programs at the Institute directed to their particular needs. As an example of exciting upcoming programs, I mentioned one event, a first-time ever colloquium called Partners in Justice, which on May 9 will bring together representatives of the bench, the bar, and clinical law school programs to focus on collateral consequences of litigation, such as deportation, eviction, loss of licensure, employment, and child custody, and to explore the potential for vital partnerships to address these often neglected but critical issues. I'm tremendously enthusiastic about the subject, about the collaboration, and of course, about the Judicial Institute. Having clean, up-to-date court facilities is obviously tremendously important to judges and staff, but it's even more important to litigants and the community. Shabby facilities demean the process, and they demean the people who come to us seeking justice. Just the other day, a family court litigant in our new Westchester courthouse said to the judge, "My case must be important because I'm in such a nice place." Fortunately, our court facilities program has been generating much-needed new courthouse construction and renovation. I would be remiss if in reporting on the latest developments on this front, I did not acknowledge the work of our partners on the Court Facilities Capital Review Board. Senator John DeFrancisco, we are so grateful to you. Assemblymember Helene Weinstein, we are so grateful to you. And the governor's representative, Edward White, who along with the chief administrative judge review every facilities plan submitted to determine whether it is suitable and sufficient to serve the locality. Very soon, we will open the largest trial court facility in the entire country, the 33-story Supreme Court Criminal Branch and Family Court building at 330 J Street in Brooklyn. With more than 800,000 square feet of new space, this new facility includes 50 Supreme Court Criminal Branch courtrooms, 24 family courtrooms, and 13 support magistrate hearing rooms. What a welcome change this will be in Brooklyn. And in 2006, a second massive New York City project will open, the full-block 47-courtroom criminal courthouse in the Bronx, again, a most welcome change and most needed facility. We have other projects in every corner of the state, such as a newly opened court complex in Jefferson County, a family and county court complex in Westchester County. We'll have groundbreakings in Putnam County and in the city of Newburgh, and of course, right outside these windows, soon a new family court and refurbished county court right next door to us in Albany, which brings me textually and geographically full circle right back to this magnificent courtroom. As I near the conclusion of this report, I am reminded of the observation of former Chief Judge Charles Breitel that judicial reform is for the long-winded. In the years I have been privileged to occupy this office, I have come to appreciate the wisdom of that insight. And today, surely, I have demonstrated my fitness for the position, haven't I? Despite the many initiatives passed and planned described in this report, I am sad, and I'm sure you are as well, that there are so many more I have neglected to mention. I do, however, want to say just a special word about our ongoing efforts regarding judicial elections. No one who has followed this issue can question our commitment to finding ways to improve judicial elections. I am very pleased to report that we recently had positive discussions with the leadership of both houses of the legislature about many of the proposals of our Commission to Promote Public Confidence in Judicial Elections, chaired by John Feerick. I am heartened by the Assembly's passage of a bill sponsored by Assemblymember Weinstein, chair of the Assembly Judiciary Committee, addressing the Feerick Commission's main recommendations. Furthermore, I am heartened by our talks with Senator DeFrancisco, chair of the Senate Judiciary Committee, who has also expressed a willingness to discuss the issue with us. We are greatly encouraged and hopeful that the legislature will enact meaningful reform responsive to the Feerick Commission's findings and recommendations. We welcome Albany's interest in the subject and agree that with the Commission that legislative action by elected officials is far preferable in the first instance to the exercise of the judiciary's constitutional power to regulate judicial conduct. In the meantime, we have already established a Judicial Campaign Ethics Center to respond to candidates' ethics questions and serve as a resource in this area. We have begun developing online voter guides to enhance voter knowledge of judicial candidates, and we will soon be reviewing the rules governing judicial conduct to clarify the boundaries of permissible campaign speech by judges in the aftermath of the Supreme Court's decision in Minnesota against White. In short, it is our hope that 2005 will be a banner year for judicial election reform. All New Yorkers owe a great debt of gratitude to Chairman Feerick and all the Commission members for their outstanding efforts. And on that note, I close. We all rejoice in the widely heralded reports of declining crime in New York, fewer domestic violence deaths, a reduced foster care population, increased adoptions, and greater child support collections. I have to believe that the court's efforts over the past decade, through diligent processing of mountainous dockets, and through leadership in innovative measures to prevent recidivism and address other vexing societal issues that are brought into court, have also contributed to this most welcome news. Obviously, the savings for the state, dollar saving and life saving, are enormous. For the New York State court system, this has been another successful year meeting heavy demands with skill, with energy, with creativity, with sensitivity, and you guessed it, with dedication. Thank you.